give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is now open. Please be seated.
Good morning and welcome to the Massachusetts Appeals Court on this Thursday, January 5th, 2023. Getting a little ahead of myself here. I am Justice Ditkoff, and to my right is Justice Singh, to my left is Justice Grant, and we'll be the panel for all the cases today. We're down to 5. Hopefully we'll keep 5. I should tell you this argument is going to be live streamed on our YouTube channel, so just be aware of that. We have some new, or not new, but not everyone here is as experienced as last time, so I know you two don't need to know this, but we have 15 minutes in the appeals court. There is no rebuttal. We have a light that will count down, a clock there that will count down your time. When you get to 1 minute 30 seconds, it will show yellow. When your time runs out, it will turn red, and we'll start counting up on how much time you're over. When the light turns red, you can finish your sentence, but don't say anything else unless you're answering questions from one of the judges, in which case, please complete your answer and see whether there are any further questions. We have definitely read the briefs. We've looked through the records, so you don't need to give us the background. You can jump right into your argument. With all that being said, I'm very pleased to call our first case and welcome the same lawyers we saw at the end of our last session. This case is number 21P948, John Doe number 460386 versus the Sex Offender Registry Board. Counselor, whenever you're ready.
Good morning. May it please the court. Attorney Xiomara Hernandez for the plaintiff appellant John Doe. I'm here today to request that this court either lower my client's classification level or remand the case back to the board. As you saw in my brief, I argued that the hearing examiner committed multiple errors in applying the regulatory factors, specifically regarding factor 10, which is a risk-elevating factor concerning an offender's contact with the criminal justice system. The hearing examiner lists 3 very minor and pretty distant cases that my client was charged on. One of them was quaffed, and one of them was dismissed, and the other one he received probation on it. The hearing examiner failed to indicate how much weight he gave this risk-elevating factor, and because of that, I believe it was error for her not to indicate how much weight to give it. In addition,
he never mentions it again in his sort of, sum up. What's your best argument that this actually affected the classification that he chose?
Well, the fact that the hearing examiner...
I'm sorry, she chose.
Yeah, the fact that he applied this risk-elevating factor would lead me to believe that there was some weight that he gave it at least, but we don't know how much weight. And if you read the, the regulation, it indicates there's different things that the hearing examiner should take into consideration when determining how much weight to apply to it, such as, how minor the offense was, how long ago it was, how many offenses. In this case, there was 3 very minor offenses that happened over a decade ago, and one of them happened over 2 decades ago. So I would argue that it's unclear exactly how much the hearing examiner could make it clearer. In addition to that, there was 2 risk mitigating factors. Factor 33, which is the home situation and support system, and factor 34, which is the stability in the community that the examiner doesn't even discuss in the decision. Here, my client did have a pretty supportive home environment and support system and stable in the community. Well, not necessarily in the community, but he was stable in the sense that while he was incarcerated, he received no disciplinary reports. In addition to that, he did complete sex offender treatment. And he did testify that he had a brother that was very supportive of him, that indicated that he was willing to support him in terms of emotional support, transportation, employment, and even housing.
But all those factors actually were considered, right? They weren't completely overlooked.
But these factors, factor 33 and 34, were not even mentioned in the decision. It's not like he decided to mention it and say, I'm choosing not to apply it, or I'm choosing to give it minimal weight. He just doesn't mention those factors at all. And as I indicated, my client had no disciplinary report, so he was incarcerated. He completed sex offender treatment. He did have a brother that was willing and able to support him. He did have some background in terms of college and had some pretty good job experience. His background is electrical and engineering, and he had possibly some jobs lined up for after he, was released from incarceration. But we don't know,
I didn't see any place where your predecessor raised anything about factor 33 or 34 in the Superior Court. Did I miss it?
There's not per se. I don't think he specifically mentions those factors, but he does argue that there wasn't substantial evidence here for my client to be classified at the highest possible level. Again, my client was convicted of just one index crime, which happened over a decade ago. When he was released from incarceration, he was scheduled to have 5 years probation, which that's a factor that hearing examiners do look at, and this hearing examiner did look at. There was no D reports. He was 51 years old at the time of the classification hearing, and as you know, the older an offender gets, the risk of him reoffending decreases. And again, he has stable and supportive home environment. He was administered the 99R, and also the stable 2007. I believe it was 2018 that those were administered, and the person who examined him determined that he posed a low to moderate risk of reoffending. My client does accept responsibility for his actions, and he is remorseful, and he is committed to not reoffending. And for these reasons, I would assert that this court should either remand the case or lower the classification level on its own. And if there's no further questions, I'll rest on my brief.
Wonderful. Thank you so much, as always.
Thank you.
If it pleases the court, David Chennai for the board. It's refreshing to be in front of you and not be arguing a misapplication of Factor 2. The board's position is the hearing examiner's decision was well thought out, well reasoned, based on substantial evidence and a proper application of the board's factors to that evidence. I think Factor 10, I think the wild card on Factor 10 is the fact that his last charge was in 2011 for a stalking, which he ended up with a violation of probation. His record stops there because that was the year he was arraigned for his sex offenses, and then he was incarcerated in 2015. So, that kind of puts it in a different light. I mean, I could say that if this individual had been living in the community since 2011 without committing another sex offense, I think that would be a different circumstance. Although I don't think that the hearing examiner relied too heavily on the criminal record. In the actual application, points out the criminal record, and then in the discussion section for risk and danger points out that he did have these charges.
It's so odd that the examiner doesn't mention minimal weight or I considered this factor, especially this examiner who I'm used to seeing pretty thorough stuff from. Any insight you can provide on that?
I do not have any insight into the decision-making process or why she didn't actually put a weight on Factor 10. Again, I think she discusses it in her discussion, and maybe she believed that was sufficient for the analysis. And again, I don't think that the record was as important a factor as the recency of the sex offending behavior, the fact that he was still incarcerated. She gave him full credit for his sex offender treatment, which is interesting because in his testimony, he described the sex offenses as accidental touchings, which could have caused the hearing examiner to say, I give the sex offender treatment less weight because there's an issue of how much he minimizes his sex offending behavior. She didn't do that. She gave him full weight for the sex offender treatment.
And you agree she's entitled to do that?
Excuse me, yes. It's in the prerogative of the hearing examiner to make that determination. So I think the hearing examiner was fair in the analysis and the application of mitigating factors. As to factors 33 and 34, there just wasn't really any evidence to support the application of them. All we really had was the plaintiff's own affidavit stating these things were going to happen or that he had a support network. No letters from a future employer, no letters from his brother, no other information. So I don't think it was fatal to the decision that the hearing examiner really didn't consider factor 33 and 34 because the evidence just wasn't there. And those are two factors where the offender has the burden of bringing the evidence forward as opposed to the board. So unless there's any further questions, I'd be more than happy to rest on my brief.
All right. Thank you both. This was very thoroughly and well briefed, so I think I understand we don't need a really extensive argument. And as always, we're very grateful for the great job you two do on every case.
Thank you. Thank you.
All right, I'll call the second case of the day, 22P 245, O'Hagan versus O'Hagan. Counselor, whenever you're ready.
Thank you. Sorry. Thank you. All right. Good morning, Your Honors. Ann Cascanet for the plaintiff and appellant, Marguerite O'Hagan. So today's appeal is from a civil contempt regarding an issue of alimony. Under the statute, for review of civil contempt, my brother is correct. It has to be clear and unequivocal, and the complaint is intended and only reversed upon abuse of discretion, which is exactly what happened here in the underlying court. Here, there was a divorce agreement, and you can see the most important exhibit would be Exhibit H for alimony. The second paragraph starts off with the fact that the husband will pay an additional alimony in the amount of 25% of all amounts earned in each year of salary. And the same paragraph ends with the same proposition that there will be a check given to the plaintiff in an amount equal to 25% of his gross income above $250,000. So the issue here.
The judge interpreted that, as I understand it, that those words gross income in the bottom line of that paragraph to refer back to the definition in the first sentence, or I guess it's all one long sentence. Why is that an abuse of the judge's discretion?
Because it's very clear that it's 25% of all amounts earned in each year of salary. The following list of bonuses and sums were specifically included during negotiations for settlement because those were specific items that the husband wanted to exclude, so they were specifically included. But that's why it was reinforced at the end of the paragraph that it's 25% of all gross income above $250,000.
If it's salary bonus or stock cashing out. I mean, that's what the agreement says, not any income.
And a check in an amount equal to 25% of his gross income above 25%. And in the beginning of the first paragraph, it starts with, will pay additional alimony in each year in an amount equal to 25% of all amounts earned in each year of salary. It's undeniable. It's 25% of what he makes above his base salary of $250,000.
If it's salary.
It is part of his salary. It's reported on his W-2.
It's strange for salary to be required to be paid back if you quit. That's not how we normally understand salary. It's something you get to just keep. I mean, so why is it salary if you have to repay it if you leave in the next 2 years?
But it's not just salary, Your Honor. The guiding statute for alimony is 208, Section 53B.
But are we under the statute? I thought we were interpreting the agreement.
Yes, but the statute defines what includes income in alimony, which is...
Does the agreement incorporate the statute?
It does automatically in the fact that it deals with the issue of the income and how income is determined through the statute. The statute defines what income is, what gross income is, and that's what it relates back to in the agreement, that is 25% above his gross income of $250,000. Gross income is specifically identified within the statute, laying out what's included in that gross income.
But can't the parties agree to something else that's beyond what's in the statute or different?
No, pursuant to Zelensky versus Zelensky, it's binding on the court to determine all of the income that should be included in the alimony, and if the judge would like to divert from that, then they have to give specific listings and reasonings as to why that should not be included.
But wasn't Zelensky a case where the judge determined alimony after a trial?
Yes, it was.
Here the
after a
parties
trial.
have agreed to alimony in a separation agreement.
Yes.
Does that matter?
No, it doesn't. The statute still controls the income defining of alimony. Here, it again specifically.
Well, if the statute controls, then why should the judge have considered this agreement at all? Shouldn't the judge have just set alimony discretionarily?
Well, the judge can generally do it discretionarily, but only if the parties raise it. Otherwise, the judge is limited to the statute and must follow the rules of the statute. Here, there's been no deviation from the statute. Gross income is gross income. It specifically states bonus and sums because those were specific items husband was trying to exclude. But it starts the paragraph and ends the paragraph that it's gross income, 25% above his base salary of $250,000, regardless of what that is.
So if he won the lottery, would that be part of his gross income within the meaning of this?
No, because this specifically says gross income and reported on his W-2 from his employer. A lottery would not be part of his W-2 income. It'd be under a 1099 or something else.
It just says he'll provide a copy of the W-2 form. It doesn't say the W-2 form controls.
Well, a copy of it and then a check in amount equal to 25% of his gross income above $250,000, and that's how you determine.
Why wouldn't that include the lottery?
It wouldn't. That's what I'm
I
saying.
understand.
A lottery wouldn't be on a W-2. It'd
But
be
why
on
does it have to be on the nothing here says it has to be on a W-2. It just says he has to provide a copy of the W-2. And by your reading, you say a check in the amount equal to 25% of his gross income above $250,000. So I don't understand why lottery winnings wouldn't be part of his gross income. Doesn't the statute include lottery winnings?
Yes, but those would have been lottery winnings at the time of the divorce. Because lottery is a separate section. If you go through the child support guidelines and whatnot, lottery earnings are separated out from the time of divorce till after the fact.
What do we make of the fact that this was brought as a contempt and not a modification? Does that make a difference?
No, because it shouldn't be a modification. There's no substantial change in circumstances. His income is his income, and she's entitled to 25% above his base salary. Furthermore, if you refer to my brother's case of Smith versus Smith on page 784 of that appeals court decision, it specifically says, as noted, however, the two issues are distinct. A party may not be in contempt, yet still owe alimony under the existing court order. So it's fine for the discretion of the judge to say, look, I'm not going to hold you in contempt because, maybe I don't really think this was your intent or whatnot. But the fact is, she had no discretion in what actually includes the income, which is the gross income, 25% from his employer, over $250,000. There's no discretion. Whether she wants to hold him in contempt, there is absolutely discretion there. But the fact that he did not pay the full alimony per the
If
court
she has
order-
discretion not to hold him in contempt, then how can we reverse the finding that he's not in contempt?
You don't have to reverse the finding that he's in contempt, but what does have to be reversed or remanded is the issue that the alimony wasn't paid as properly indicated. Whether the judge feels that he did so intentionally or maliciously can play into her decision of whether or not he's in
For
contempt.
contempt,
which
there
doesn't
has to
cover
be
here.
a deliberate violation of a clear and unequivocal order. Which did the judge find here, or both?
Actually, the judge doesn't really say anything. In the decision, it just simply says that he's not in contempt for not paying 25% of his, quote, award, end quote.
But so aren't you asking us to rule that this alimony Exhibit H amounts to a clear and unequivocal order that he pay part of this award as
Yes,
alimony?
that's exactly what we're
But if the judge didn't find him in contempt, didn't she implicitly find that it wasn't a clear and unequivocal order?
No, she doesn't indicate one way or another. She could have found that it was a clear and unequivocal order, but she could have also found that he didn't do it deliberately because in the year prior, if you look at the transcript, there was a small award of about $10,000 that my client didn't dispute at the time. So he very well could have thought of the fact that, oh, well, she didn't fight me over the $100,000.
She should still order him to make the payment.
I didn't put that in my initial brief. It's part of my rebuttal to my brother's response, which I could
No,
add
below.
further memorandum. I'm
Before-
sorry.
Before the probate judge, where did you say that?
Where did I say to the judge?
Where did you say to the judge, even if you don't find him in contempt, order him to pay the money?
I don't believe that was specifically said.
Wouldn't that be a modification?
No, a modification would have to be, we're not looking to modify the agreement. We're looking to enforce the agreement of the 25% of his gross income.
So you're saying your complaint for contempt encompasses both the request to find him in contempt and whether or not you find him in contempt to enforce the agreement?
Correct.
Let me ask you this. The judgment is entered on November 4th. December 4th is a Saturday. So I would think the notice of appeal would have been due Monday, December 6th, but it was filed December 7th. So how do we have jurisdiction?
Well, you do have jurisdiction. If I recall correctly, it was, I don't have the full docket in front of me, but I believe it was filed timely and there was an issue with the filing, the electronic service itself, because there was issues with the payment going through. So initially, the appeals court also put forth that the payment hadn't been made, so the filing wasn't complete, but then had to go backtrack through the system and found that it was paid. So eventually, that part of it was withdrawn.
Well, the docket says the notice of appeal was filed on December 7th, and the notice of appeal in your appendix doesn't have a stamp on it showing me December 6th. It's dated December 6th. Did you mail it or did you file it in person?
Honestly, Your Honor, I don't recall if it was filed in person or mailed.
I mean, so if you mailed on December 6th, it probably wasn't filed until December 7th, which would be a day late.
That is correct, but the postmarking would be the date of service and filing that the court would recognize.
Why?
Because generally that has been the standing. It's filed and served upon mailing.
Not upon entry?
What says that a notice of appeal is filed on the day it's mailed, except in the situation of a prisoner? I know there's a rule that says that for a prisoner, it's filed on the day it's mailed, because they can't control.
Well, I
They can't
believe
go
it
down
was
to the
filed
courthouse.
electronically and mailed the same day.
Then why does the docket show it on the 7th, not the 6th?
That I could not answer offhand, but I would say if there was an issue of timeliness, it would have had to been raised or it's waived.
Why wouldn't that be jurisdictional, whether the appeal is properly before us with a timely notice of appeal?
Because if timeliness is an issue, then it has to be raised as part of the appeal process, or, you know, it's no different than if a party files something late or doesn't file something at all, and there's no objection, and it gets entered because it wasn't raised. But as far as I'm aware, it was filed both electronically and mailed on the 6th, which is why I assume there was no pushback on why it wasn't on the filing time. Any
Right.
further questions?
What exactly is this award for? Do we know from the record? I know it's in the record, but do we know what it's for?
My understanding is there was some sort of merger at the company that the husband was working for, and due to his work on that merger, and the merger, I guess, was very successful, so he got this additional award, which he gets different awards year to year, which makes up a large portion of his income. And the alimony was set up on his base because the parties felt it was unfair to make him pay an alimony based on his overall income when he only gets that at the end of the year based on his bonuses, because he gets his base salary on a normal basis. And that's why the additional alimony was set up after the fact, so that way the parties could figure out how much he actually earned that year, because his income changes from year to year based on the bonuses and additional awards and income he receives from his employer.
Thank you.
All right, thank you very much.
Thank you.
It's been very helpful.
Good morning, Your Honors. My name is Barry Backrack, and I represent aptly Mr. O'Hagan. Starting with the last question, the award was an extraordinary award as on its face. It's on pages 71, sorry, I had that, but it's an extraordinary award for being part of the orchestrating of the merger, a major merger. And as Justice Ditkoff mentioned earlier, it could be, if he didn't stay a full time or was dismissed, he would have to pay back part. I'd like to address the issue of the judge's ruling, and the judge indicated he did not commit, that Mr. O'Hagan didn't commit a contempt. And her ruling could have been one of two, which could support. One, she could have ruled under contract principles that the order was clear and convincing, but he met it. And she would have, to do that, she would have read Exhibit H, where it indicates that is 25% of all amounts earned, equal to earned in each year of salary, bonus, and sums he receives. And then later, my sister refers to the gross income, which is a very general term. And under general contract interpretation, the specific controls the general. So the judge could have contractually ruled that this only referred to stocks, salary, bonus, and stocks. And in particular, why she could have done that also is it because it talks about how the payment's to be made. And that provision's put in there to identify a specific bonus which ties back to the reason why it was salary, bonus, and stocks. Alternatively, the judge could have ruled that it's ambiguous. In trying to resolve the ambiguity, if she was going to make a final decision, she could then take into account specific controls general, but she wouldn't have to. If it was ambiguous, then it's not a clear and unequivocal order, and he would not be found contempt.
You agree the judge could have said, not guilty, but I interpret this agreement as meaning X, do that from here on out, right?
If she had been urged to modify it, and I understand the point that the court's making, the trial court has power to modify in connection with a contempt. But the cases that I found where that happens were in 2020, there was a case involving, I just went to a seminar that told me, don't be shuffling through your papers, and what am I doing? In any event, there was a case in 2020, and I can get it for the court, where the Supreme Judicial Court reversed on the grounds that the judge erroneously refused to allow a counterclaim to modify in contempt of a contempt action. Then there's a 2013 case by this court where the trial judge actually went ahead and modified it, didn't find contempt, but made an award, and the court upheld it and indicated that that was the court using its power to modify. But in this case, there was never any counterclaim brought, there was no modification sought.
But even without modification, couldn't the judge say, well, this agreement is ambiguous, so there's no contempt, but you should understand that the best construction of it is X, and that's how you should treat it going forward? Sort of a declaratory
Without
judgment.
conceding that that's how it should have happened, yes.
I'm not saying should have, but could, has the power to.
The judge could have done that, but she was urged not to.
So doesn't this case need a remand? Because, you know, your argument is the judge could have done this and might have done this and might have been thinking this, and we don't know.
Well, we know she denied the contempt.
And we don't know on what basis.
And then the issue becomes, before this court, it could have ruled, it could have addressed a modification if one modification had been raised, or if the judge refused to allow them to modify. But that was never, the issue was presented to the judge as being black or white. It either, there's contempt or no contempt. And I don't think it would be appropriate for this court to remand the matter, because in a situation where the issue of modification or the judge was never told, even if you don't find contempt, you should construe the contract this way. She could have brought a declaratory judgment counterclaim. She could have brought a counterclaim for modification. Because even if there was a substantial change, she could have done that, but she didn't. And so I mean, you'd be doing is sending it back to the judge to make a ruling on her contractual rule, make a contractual ruling on, you know, whether or not the award was included in the separation agreement that was entered as an order.
Is there any light you can shed us on the notice of appeal? Do you have reason to believe it was filed on the 6th?
So, Your Honor, I'm sorry. I never even.
I know you weren't the
focused on this. I think I got involved afterwards. I just.
If you don't know anything, that's fine. Just if you did.
I mean, I guess it's an issue. if it says the 7th and it was supposed to be the 6th, this court has jurisdiction, because it's subject matter jurisdiction, the failure to file a notice of appeal timely, this court can raise it at any time, now or before. I just don't know what the circumstances were.
Okay.
Does the court have any other questions?
No?
Thank you very
Thank,
much.
thank you both. This was very helpful. Ms. Cascanet, it's always great to see such an experienced trial attorney come and come do appeals. I know you, of course, very experienced here, but it's great to welcome you to our rank of lawyers.
Thank you.
All right. Do we have Mr. Kaplan here? Ah, wonderful. I'll call the fourth case, number 22P174, Linder versus Pollock. Attorney O'Brien has waived oral argument, as is his right, and I understand you have not.
I have not.
As it's also your right, and so we will proceed with your argument whenever you're ready.
Thank you, Your Honors. I'm Norman Kaplan. I represent the appellee, Paul Linder. He is the plaintiff in the...
Could you
Yes, he is the...
move the microphone maybe a little closer to you or speak up a little?
I didn't want to touch it. I saw the rules that don't touch the microphone. As I was saying, Mr. Linder is the appellee here and the plaintiff in the underlying claim, a contract case for the failure to repay a loan. First of all, my apologies to the court for the errant prefix on the numbering of my brief. There is an RA/ before each number, and that doesn't belong there. I just noticed it. I don't know how it got there, and I hope it did not cause the court any confusion. I'd like to first address the threshold question posed by this court when it sent an email to counsel asking us to review the case of Institution for Savings in the light of whether or not this case is properly before the court, given that it is, what is being appealed is an interlocutory order. As the court may know, National Lumber, which was decided in 2018, was followed in 2019 by the case of, Institution for Savings, 2018, was followed in 2019 by National Lumber versus Royal Tax Lien Services, a very analogous case. In both of those cases, the appellant created a dubious, I would say, workaround as a means of obtaining what the court referred to as temporary finality in order to permit the interlocutory appeal. This court, in both instances, deemed the strategy to have undermined the judicial gatekeeper role in limiting appeals of interlocutory orders. Nevertheless, in both of those cases, in Institution for Savings and National Lumber, do
you have a citation for National Lumber?
Excuse me?
Do you have a citation for National Lumber?
Yes, I do, Your Honor. 95 Mass Appellate Court, 1103, 2019. It's an unpublished decision. Nevertheless, in both of those cases, the appeals court did exercise its discretion and addressed the merits of the case, even though there was no prior judicial approval. And I submit respectfully that the court should, in this case, follow suit. Therefore, I respectfully suggest that the issue raised by this panel for discussion is not whether Mr. Pollack's appeal is properly before the court. It clearly is not. But whether the court should exercise its discretion in addressing the merits of Mr. Pollack's appeal. Throughout this case, Mr.
I
Pollack
assume with
has-
the delays your client's been experiencing, he would much prefer us to reach the merits? Is that right?
He would prefer an up or down decision on the merits. And I'd like to go into the reasons for that. Throughout this case, Mr. Pollack has run afoul of various governing practices, but he alone was prejudiced by his failures, fairly, I might add, by not answering the complaint, by not responding to Linda's discovery, filing motions without complying with Rule 9A, Superior Court Rule 9A, not filing an affidavit in support of his motion to vacate the default, not showing up for hearings or argument. But now, if this court declines to decide on the merits, it is Mr. Linda, who did nothing wrong, who will be unfairly prejudiced. In my brief, I did observe that this was an interlocutory order. It's not as though it went by me. I did notice that. However, since I could not be certain whether this court would exercise its discretion to decide the case on the merits, I had no choice but to defend it as if it were a final order, a final judgment. And if this court then, if there's no decision on whether to affirm or reverse the lower court, Mr. Pollack then will have another bite at the apple.
Won't he still, though?
Excuse me?
Won't he still?
But it's much less likely, Your Honor. First of all, if the court affirms Judge Campo's order, then it goes to an assessment of damages, and more than likely, that would be the end of the case. You won't see us again.
Well, there's another appeal from that, right?
Pardon?
Then there would be an appeal from that.
Well,
Judgment.
it wouldn't be precluded, but I think it's much less likely on an assessment of damages that there would be an appeal. If the court reverses Judge Campo and the case goes back for a trial on the merits, sure, there's a possibility. What I'm saying is, by deciding the case one way or the other, this court is minimizing the likelihood of an appeal. If they don't, it is almost a certainty you'll see us back here for the third, unfortunately, for the third time. I don't mind being here, but unfortunately, my client has to underwrite the costs of my opposing a third appeal by Mr. Pollack, and I'd like to avoid that, and so would my client. Therefore, I do respectfully submit that the court should again exercise its discretion, address the merits of the appeal now, and that way to minimize additional costs for my client and to minimize the further delay in bringing this case to conclusion. By deciding the case, it will advance the case. Of course, I'm assuming that if the court rules that this, in the event that the court were to rule that this appeal is not properly before it, the case would return to Superior Court without prejudice to Mr. Pollack appealing after judgment. I'm assuming that to be the case. I see I have half of my time left, and if the court has no questions on the issue of whether the case is properly before it, I'd like to just go through a few bullet points on the merits, if I may. So why should this court affirm the lower court's decision to deny the motion, Mr. Pollack's motion to remove the default or vacate the default? First of all, Mr. Pollack neither appeared at the hearing on that motion to vacate the default, nor did he file the required affidavit to show good reason for failing to plead or defend in a timely manner, or that he had a meritorious defense. On those grounds alone, Judge Campo was well within his discretion to summarily deny the motion. And on that basis it shouldn't be reversed. In fact, I don't think he had a choice. The law is very clear. On a motion to remove a default under Rule 55C, which is what this should have properly been decided on, the case law says that an affidavit by the party must be filed, and it must show a meritorious defense and an explanation, good reason why the answer or failure to, why there was a failure to plead. And that's missing here.
So one of the ways that I think Judge Campo approached this was, given the fact that there was a request for admissions served in June of 2018 that the defendant never responded to, and those are deemed admitted after 30 days, and he still hadn't responded to them. I know sometimes pleadings, because of 9A, don't make it to the docket. Do we have anything in the record or any reason to believe that Mr. Pollack has ever responded to those requests for admissions?
Well, I can represent to the court that he never did. And in fact, I think that's conceded in Mr. O'Brien, Attorney O'Brien's brief. He talks about how, well, maybe in the future that could be forgiven. So I think we can say with all absolute certainty. But Justice Grant, I would add to that, and it's true that that is one of the factors that Judge Campo took into consideration, because he references my brief and my reasons. And that was only one of the reasons. And the other reasons were the lack of an affidavit. And I went through a number of reasons.
So even if Judge Campo had allowed the motion to remove the default, that would be futile because the admissions are deemed admitted.
Exactly. And I as I said in my brief, I think to Judge, it was either to Judge Campo or to this court, it would just have been an empty gesture, because it's been 4.5 years, Your Honor, since this case has been filed. He still hasn't filed an answer, or as most lawyers would do in a situation like this, they would serve a prospective answer just to show good faith, and that wasn't done here. So he then brought a motion for reconsideration, all right? So he had a second opportunity to argue the case, explain. Neither Mr. Pollack nor his attorney appeared on the motion for reconsideration. Even without an affidavit, if Mr. Pollack had simply appeared, Judge Campo could have put him under oath, and he could have testified as to reasons for not answering, all the delay, why haven't you answered the interrogatories, where is your document production? So to sum up, there's no evidence here of any effort by Mr. Pollack to defend this case in any measurable good faith way. And there's nothing in the rules of civil practice that would have prevented Mr. Pollack, even with the default, from answering the interrogatories, filing an affidavit, producing some documents to support his defenses. Instead, the only thing he does is suggest that there was a check that he had forgotten about, and now he remembered. Well, that isn't newly discovered evidence. That's something that's been forgotten and newly remembered. And that doesn't cut it. I mean, the law is very clear. To say nothing of the fact that in the complaint, Mr. Linder references that very issue, so it's not as if the court was not aware of it. So for all of those reasons, I respectfully suggest and recommend that this court accept this case for decision on the merits and affirm and uphold Judge Campo's valid and well-supported decision to deny relief to Mr. Pollack. Thank you, Your Honors.
Well, thank you. This is helpful. I'm glad you came in to argue the case.
So am I. Thank you, Your Honors.
All right. I don't see enough lawyers, enough people that we can go further. Do we have any? I think maybe Mr. McCulco in the background, in the back? No. All right. All right, well, then we are going to have to recess.
All rise. Mr. Duhon, thank you for your clerkship today, sir. Thank you.
All right, we are back in session. Let me just run through the rules. I know that you two don't need it, but since we've had the break, I'm Justice Ditkoff. To my right is Justice Singh. To my left is Justice Grant, and we're hearing the last two cases. In the appeals court, you have 15 minutes per side. There's no rebuttal. There's a clock that's right there on the podium. It will start counting down the 15 minutes. So once you start, when you get to 1 minute 30 seconds, it'll turn yellow. And then when time runs out, it'll turn red, and it'll start counting up on how much time you're over. If it goes red, you can finish your sentence, but don't say anything else unless you're answering questions from the judges, in which case, please answer the questions. Everything here is being live streamed on the internet, so just keep that in mind. And finally, we have read the briefs. We have looked at the records, so we're aware of the case. There's no need to summarize it. You can jump right into your argument. Now I'll call the next case, 22P212, Collins versus Franklin. And I'll just remind the parties, I'm sure you two need no reminders, but we won't be naming any of the child victims in this argument. Counselor, whenever you're ready.
If it please the court, David Hirsch for Mr. Franklin. The prosecutor asked the jury in closing, do you collectively believe that Mr. Franklin is not likely to reoffend sexually in the community if he is to be released without further treatment? It's hard to imagine a more blatant reversal of the burden of proof than that. Do you believe he has proved it? He has nothing to prove. It's their burden, and she reversed it. And that's not the only time. There were 4 times in the last 2 pages of argument. We know that, excuse me, we have to look at the closing as a whole. But we also know from one of the 2 Nemec cases that it's worse when the misstatement, when the impropriety is at the denouement of the prosecutor's remark. And that's what it was here, all 4 of them. Did
the defense counsel object on those grounds?
No. So this is obviously a substantial risk of miscarriage of justice, and I'm having a little trouble here.
Why don't you grab some water?
I'll have a little more water.
I could never argue without drinking water.
Nor can I. The Commonwealth asked Mr. Franklin, well, you could have transferred to this other facility. You could have applied, that is, for transfer to this other facility that has more treatment. That not only puts a burden on him, but I think it comes very close to, if not crossing, the line established in Commonwealth versus Hunt, where the court said, you can point out the absence of treatment, you can't point out the refusal of treatment. He didn't do what he should have. That's awfully close to the Hunt prohibition. Then there's the Commonwealth.
But if the prosecutor hadn't asked that, mightn't it left the jury with the impression that the treatment wasn't available anywhere?
Your Honor, since the burden is on the prosecution at all times, I don't think it's an issue in this case. If they still could have pointed out, if they wanted to, under Hunt, if I don't even remember if it's the case here, well, you didn't do treatment. But you didn't apply for something that might have been available elsewhere is going far beyond that. Then in...
Why is that different?
Well, again, in Hunt, they talked about refusing treatment. How far a leap is it from refusing treatment to saying he didn't go look for better treatment than he already had? This is reversing the burden. It's establishing a requirement for Mr. Franklin to do certain things to be worthy of release, to be worthy of being found not sexually dangerous, and that's not the law. Then the Commonwealth responded to these arguments in its brief by citing the Greer case. Well, in Greer, the defendant made a third-party culprit argument, and the Commonwealth rightly pointed out there was no evidence to support it. What the Commonwealth didn't do in Greer was say that, has he convinced you that his theory is true? That would have been, as here, a reversal. Never said that Mr. Greer failed to prove his innocence. Never speculated as to what might have happened that didn't happen if more time had been allowed, as, excuse me, as the prosecutor argued concerning Mr. Franklin's most recent offense.
Well, when a defendant testifies, why can't the prosecutor ask whether that testimony was convincing?
The prosecutor can, but there's a difference between, there's a linguistic difference between is it convincing and has he convinced you? I think there's quite a gulf between those two. Has he convinced you is a blatant reversal of the burden. No, my client does not have to prove to convince you. They have to prove that he is sexually dangerous. The next issue I'd like to address, all 5 of the experts said that Mr. Franklin's static 99 R-score was 3, corresponding to a 7.9% likelihood of reoffense. That created a problem for the Commonwealth because the science was against them. And the prosecutor, how did this prosecutor respond? Don't pay attention to the scientific evidence. Don't pay attention to the actuarials, to the studies. I don't believe, Your Honor, that it's appropriate for a prosecutor to say, ignore the evidence. It might have been fine if the prosecutor had said, well, here's what's wrong with that evidence. Here's why you shouldn't give much credence to it. Here's why...
Well, the prosecutor did that as well. The prosecutor argued that it's a static, and so the question was Mr. Franklin in that, that group, or was he in that group that reoffends, and that he then argued that when you consider the dynamic factors, that Franklin was in that. Why isn't that appropriate?
That would be entirely appropriate, and we have no objection to that. The objection is to the admonition to the jury. Don't pay attention to this stuff.
What about, ladies and gentlemen, you're the finders of fact here, not those doctors.
Again, that's appropriate. That's a different argument, but there is no, it's not okay for the prosecutor say, disregard the evidence, and that's what happened here. 2 different things.
Well, he said, don't be distracted by discussions about actuarial tools or studies or statistics.
Yes.
The focus of deliberation should be on those last 2 issues. And then he says whether there's mental abnormality, but he
I'm
means...
having some trouble hearing you, Your Honor.
He says the focus should be on those last 2 issues, and then he says whether there's mental abnormality, and obviously he meant to say, and risk to offend.
But those last 2 issues are all dependent on the scientific evidence to be presented by the experts in these cases, whereas the finder of fact is not one of the doctors, one of the experts. The jury's decision must be informed by the science that's presented to them, by the evidence that's presented to them.
But does it have to be based on actuarial tools and statistics?
It does not have to be, but it was. And a large part of it was. Statistics, actuarial tools, I listed the number of pages in which it was described in my brief. It was continually described by the lawyers for both sides. And the prosecutor merely said, that's a distraction. That's not proper. The next issue, Your Honor, and this maybe ties for the first one as the most egregious of mistakes, is the prosecutor's misstatement of fact about Dr. Johnson, who testified, the QE who testified for the defendant, and allowed at cross-examination. There might have been a contact offense had things continued between Mr. Franklin and the girl at the motel. And what did the prosecutor turn it into? That she said it was very likely. No, she didn't. She never said that. And that kind of misstatement of the evidence is crucial here, because Dr. Johnson's testimony may have been the strongest evidence for Mr. Franklin. After all, she's not a retained expert. She's one of the qualified examiners who's regarded as the linchpin in these cases. And the Commonwealth misstated her testimony. Not only did that just on its face get things wrong, it made her look foolish or dishonest. And here, unlike some other cases, there was no curative instruction. I had mentioned before the Nemec 1 case. Here, as in that case, the judge did not specifically address the prosecutor's improprieties, which were hard-driving and sustained, and which went to a critical aspect of the case. Here they went to several critical aspects. The next issue I'd like to address, Your Honor, is the admissibility of Dr. Bell's testimony regarding things that for which he supplied no support. We have cases like Walsh.
All right, so which things exactly that Dr. Bell testified to?
Well, I have listed them in the brief. The one that's coming to mind right now is that the well-known rule that sex offender reoffense drops drastically at age 60 didn't apply to Mr. Franklin because he had offended at age 57. There's no support for that provided. That's making a decision. That's positing something on the ipse dixit of the expert. And that's not permitted. And that happened over and over, and Your Honor...
Didn't Dr. Bell say that at 57, he was already at an age when statistically it would have been approaching zero?
But
Isn't
then
that different?
he said it didn't apply to Mr. Franklin. Under most cases, it would approach zero. The Commonwealth claims that Dr. Bell was a qualified examiner. Not in this case, he wasn't. Bradway says that QEs are exempted from the Lanigan requirements due to their deep involvement of the case. He didn't have deep involvement. He never interviewed Mr. Franklin. He just did enough to find probable cause, and then he left the case. He is required to meet the Daubert-Lanigan requirements, and he didn't.
How do we know there's no support for that? I mean, it's certainly in the SORB guidelines, exactly what he said, and there was no Lanigan complaint as to this.
How do we know?
There's no support for the concept that the age drop doesn't apply when you sexually reoffend at 57.
Your Honor, it's the Commonwealth's burden to show that it does, not Mr. Franklin's burden to prove that this is
in the absence of a foundation objection or a Daubert-Lanigan request on that? I mean, I didn't see the defendant's witnesses cite studies and for everything they said.
No, they did not. But, Your Honor, there is no challenge to them. If the Commonwealth wanted to, it could have, at trial or on appeal, said, well, look, the defense admitted was allowed to admit all this unsupported stuff. That's not the issue here. what the defense was able to do. The issue in any instance of whether there's a fair trial is what the Commonwealth was allowed to do that is not according to law. And that's what happened here.
Okay, but what's not according to law? What happened that wasn't according to law?
He made all kinds of claims that were based purely on his ipse dixit,
How do we know they were based on his ipse dixit and not based on studies?
because there were no cites. And because
No one asked, but without someone asking him for cites or asking for a foundation, why would there be? How can we determine from the absence of citations where no one asked for the citations that there are no citations?
that there should be, well, one, I presented some evidence showing that this is not accepted in the science. Two, it's the Commonwealth's burden to show that it is more than the ipse dixit. As if I got up there and said, well, he's likely to reoffend because he has weird eyebrows, that would be ipse dixit, and that would not be admissible. No more is the claim that, well, since he's reoffended at 57, the science we know about goes away, which is what Dr. Bell told the jury. Your Honor, the one other point, I think I'm out of time, so if there are no questions from the court, I will sit down.
All right.
Thank you.
Thank you. And of course, your jury instruction issue is preserved.
I'm sorry.
Your jury instruction issue is preserved.
Thank you.
All right, Counselor, whenever you're ready.
May it please the court, Johanna Black on behalf of the Commonwealth. I think I'm just going to start in briefly with where the respondent started in this oral argument, talking about the prosecutor's closing argument and how she was asking the jury whether they collectively believed the witness's testimony, including that of the respondent who testified at his SDP trial. As your honors know, in making credibility determinations, fact finders are allowed to take into account a witness's demeanor on the stand, what they've said, how they've said it, and all of the questions that the respondent challenges on appeal as to the prosecutor's questions to the jury about whether they collectively believed the confidence the respondent has tried to portray to them, whether they collectively believed that essentially he's not likely to reoffend. All of that is just credibility argument. It's just argument going towards whether the jury should find the respondent credible.
Well, I mean, but after having heard from all the doctors, and after having heard from Mr. Franklin himself, that's everything, that's all the evidence, do you collectively believe that Mr. Franklin is not likely to reoffend sexually in the community? I mean, isn't that the wrong question? The question is, after hearing all that, have we proved beyond a reasonable doubt that he's likely to?
Well, it's interesting because, as your honors know, a verdict, whether it's in this case that the respondent is not sexually dangerous person or whether he is a sexually dangerous person, needs to be unanimous. And when the respondent himself, in opening argument to start off this whole trial, told the jurors, you must be unanimous if you're going to find him to be a sexually dangerous person, the prosecutor is entitled to respond to that.
No, the collectively part's fine, but the collectively believe that he's not likely to reoffend sexually in the community, isn't that the wrong question?
Well, she's asking, do you unanimously find him not to be sexually dangerous? And if you do, then it's a not guilty, a not sexually dangerous person verdict. So I think she's just touching on the law that they must be unanimous either way, and she's combining it with the credibility argument. So I think she stayed within the realms of proper argument. She's just combining it. It's just a creative way, I think, of touching on two parts of the law that they, as finders of fact, have roles in. You know, they're the finders of credibility, and then they're the finders of the verdict. They decide whether the respondent's a sexually dangerous person. And similarly, when she starts talking about Dr. Johnson's the concern in her report versus her opinion that he's not likely to reoffend based on her reliance on him not being a pedophile, which is based on him denying that he's sexually attracted to children. She's, again, getting at the reliability
Right,
of
but
Dr.
very
Johnson.
likely is just a straight-out misstatement of what Dr. Johnson wrote and said.
So
Don't
I
you
think,
agree?
I don't agree that it's a straight-out misstatement. I'm just going to pull up the prosecutor's words very briefly. She's telling the jury to note certain things in her argument. I just want to make sure that I
Bottom of
don't
146?
misstate her words.
Yeah, bottom of 146.
I'm actually going to go to my brief, if that's all right, just because I have the transcripts as the respondents supplied them to the court, and the
Yeah,
pages
however you
don't
want.
match up. Apologize. So, but my recollection is that she's, in her argument, she's asking the jury to note certain things. One being parts of Dr. Johnson's report, another being Dr. Johnson's testimony on the stand, and another being the other evidence that they've heard, and combining it all.
Right, but when you review Dr. Johnson's report, note that she does identify at the end of her report concerns that the escalating behavior of Mr. Franklin, that first incident, do mirror the second incident. That's totally true. And it's very likely, based on the circumstances, based on the grooming behavior, over grooming behavior, as she refers to it, that something would have or could have happened physically as far as touching sexually with victim. But
Right.
the very likely, the testimony and the report, testimony was certainly possible, and the report is that it might have escalated.
So I think
Isn't very
she
likely just
started,
wrong?
I don't have it in front of me, I was just trying to listen to what you said, but I think she began it with review the reports with a critical eye. Is that right?
Doesn't say critical eye, but
So I think it depends on how it's presented to the jury. It's really difficult reading a transcript to see the tone and the pace and the areas where a prosecutor breaks in her argument to the jury. And I think it is significant that the defense attorney at trial did not object to that, because you could infer that when she's saying, when you're reviewing the reports with a critical eye, think about all the other evidence, like think about the, how do they review the reports with a critical eye without using the other evidence they're presented with? And so she's telling the jury, when you're reviewing these with a critical eye, note what she says in her report. But, it's very possible, and I don't have the benefit, I haven't listened to the audio recording, but it's very possible that, she pauses and she's saying, and it's very likely when she's summarizing all of the evidence, that section, she's kind of summarizing. We just don't know where she's pausing, and so I think it's really significant in closing argument cases, the law that says, you do have to look at whether or not it was objected to, because that gives you some insight into the tone and the...
You're suggesting that what the very likely was not trying to quote what the opinion was.
I think you can interpret the transcript that way, and unfortunately we're not present during her during her closing argument to know, and maybe I should have tried to listen to the audio recording, but I don't think it's extremely clear that it was a straight-out misstatement, but even if it were a misstatement of what the doctor wrote in her report, it's not something that the jury couldn't have, by looking at Dr. Johnson's report, ferreted out and realized was a misstatement by the prosecutor, not evidence. They're instructed closing arguments aren't evidence. They're instructed that they're the finders of the fact. Their recollection of the evidence controls. And again, they had her report in their deliberations. So even if it is a misstatement, and even if the prosecutor was saying, in her report she says it's very likely, or in her testimony she said it's very likely, it's not something the jury wouldn't be able to sort out as an excessive or misstatement. Especially where, and I don't think it would be harmful to the respondent, especially where there is evidence that supports that it's very likely. I mean, Dr. Johnson did also point out that the behavior was the grooming behavior, or the behavior was mirroring the prior incidents, and that it could be overt grooming behavior. So I think the very likely the jury could infer on their own based on the evidence that was presented to them.
Is there a difference, though, between it's certainly possible, which is what Dr. Johnson said, and it's very likely?
I guess it kind of depends on how you define very likely. I know likely in this case actually has a specific meaning, which is reasonably to be expected in the circumstances. Very likely in common parlance is, I think, different. Certainly possible, very likely. I mean, adding the word certainly before possible, I think, strengthens what possible means, but I'm not sure that every person would equate those phrases. But just jumping back to the sex offender treatment issue that was discussed with respect to respondents' oral argument, I just want to just point out that the questions the respondent's challenging that were put forth to him at trial by the prosecutor weren't limited to his not receiving sex offender treatment while incarcerated. They were talking about a number of other programs that he could have entered or that he could have tried to enter or apply for. And that information does go to the Bradway element of, or the Bradway factor of the possibility of successful intervention to prevent anticipated harm, which is one of the factors that's analyzed in determining whether the prosecution's met their burden to prove that the sex offender is reasonably to be expected in the context of the particular facts of the case and circumstances at hand to reoffend. So that line of questioning, this challenge, wasn't actually at that point really about sex offender treatment. It's about parenting classes and other types of classes that could help the respondent learn how to develop better relationships with children, more appropriate relationships with children, for example. So it's just pointing out, what the respondent was aware of and what might have been out there that he could have taken part in that could have provided some other means of prevention. So I think with that, the Commonwealth would just rest on its brief, unless Your Honors have any other questions.
Oh, thank you very much. Thank you both.
Thank you, Your Honors.
It was very well briefed and argued. Very helpful to the court. All right, I will call the last case of the day. Massachusetts Department of Revenue versus Michalko, number 22P328. All right, Mr. Michalko, whenever you're ready. And you can bring your water if you'd like.
Thank you.
Right.
May I please address the court? Thank you. Dear honors, it's unfortunate that I have to stand here in front of you and argue about the case that was presented from Czech Republic in terms of demanding a child support from me. I wish that it never had to happen like this. And Czech Republic, they basically, in my opinion, they have absolutely no right to demand a child support from me under the circumstances as they are. They think they do somehow, but I went through every single clause that I found, and I don't believe that they do, okay? First thing, what I'd like to say is that, see these marks on my head, these white ones?
Yep.
So, how do they relate to this case? When I was a little child, I was standing in a line, and young kids tripped me. And the reason they tripped me is because I had no father in my birth certificate. Okay? It was such a culture at that time. And I didn't understand what was going on. Basically, I came home and I have a broken head. Okay? Now, why wouldn't I have a father in my birth certificate? Okay? That comes down to what's happening right now. Czech Republic, citizens of Czech Republic organized a paternity fraud and basically defrauded me of a father in birth certificate, thus they defrauded me of child support. Now, fast forward 45 years, and by almost any chance, I met a woman from Czech Republic with whom, I have a child. And when it came to the court, I basically told the court, look, you guys owe me child support because you guys have organized paternity fraud that you are refusing to bring to justice over 45 years. And now it's almost like a boomerang that happened to you. So that's why I think they absolutely have no right for me to ask the child support. The Czech Republic right now serves as a clearing house for the justice. Even such a thing as registration of me being a father for the child. Why can't I have a registered father in my birth certificate? Czech Republic cannot really do one DNA test that is going to show that who is my father when they know who my father is. It comes down to justice. Basically, the people that organize this fraud on me, they are teachers of a justice. One person is a criminal law teacher at the highest university, Charles University in Prague, and the other one is basically a lawyer, and they were, doing whatever they were doing, Somehow they decided that they're gonna manipulate the whole process so that I will be fatherless on my birth certificate. That's what they did. Now, when I pointed that to the court, I don't believe they want to hear that. And if they do want to hear that, they want to separate it, and that's a separate case from the current one. But I don't believe that's a separate case. It's the same case because if they did what they were supposed to do, I would have a father in the birth certificate, I would collect my child support, and now we wouldn't be standing here because I wouldn't have any objections to that. I would basically be perfectly fine with what they did, and I would be more than happy to pay the child support.
But how can the response to the denial, the outrageous denial of child support to you, to be denied child support to your child?
I look at it, I didn't know that what Czechs did. I didn't know until a mother of a child started to behave weird. She basically started to cook things against me so that she would have some supportive stuff in a court to collect the highest possible child support. And when I saw what she was doing, I said, enough is enough. And I started to investigate and went paper by paper, document by document, and basically I found out that what they did is they manipulated the process, they forged the blood twice, and they made it look like it was perfectly fine. And, and when I find out about that, and I communicated to the lawyer, she would just stand there and just, be quiet. When I asked her, about, what the court said about what I told her to say, she didn't really reply to that anything,
How did you obtain the lawyer you had in the Czech child support case?
What I did is, I live in the United States, okay? So I went to New York I'm originally from Slovakia, so I went to New York and I went to Slovak community gatherings, Czechoslovak community gatherings. And there were some people from Prague that studied in United States. And basically I met them and I started to ask them, look, I need a lawyer in Czech Republic and would you know about somebody? And the gentleman, he was in my age, said, yeah, he knows. So I said, great, that's great. So he hooked me up with the lawyer. I went to Czech Republic and basically it was his father. I met with them and basically he assigned the case to one of her, I would say, associates or lawyers or things like that. So that's how I ended up with the lawyer. Now, initially, things were fine because I kind of liked her, and she was just a lawyer. But when it came to the point when I started to object about things, when I literally accused of one of the high-ranking officials of I'm going to call it a judicial fraud, that's when they wouldn't even want to talk about it. It was like they wanted to buckle up the whole case, finish it, and separate it. So that's when I figured that they know each other. Not her, the lawyer, but her boss. So, and then when I started to investigate it further, they're all interconnected. Like, it's almost, I hired a lawyer that I would like to do the service for me. However, it came to the point where she was watching over her back. If she basically opened up her mouth, started to pursue the things, she would probably lose the work. And in Czech Republic, it's not like you can just pack up and go to a different state, different city. You have to play the game, otherwise your living is on the line, okay? And the individuals that are part of this organized fraud, their reputation is on the line. Everything is on the line. Especially the generation of judges went through their education. It's almost like you are a judge and your teacher did the fraud, and you're supposed to take action against the teacher. You probably are going to be like, well, you are going to overlook it. Maybe. Well, I'm not going to say you're going to. In Czech Republic, I believe that's what's going on. Okay, they are hiding a crime on a judicial level. My DNA is the proof to that, and somehow they want to buckle it up under the rug so that it never comes out, because those individuals are old and they wish they would just die so that, say, well, that's what happens. So that's the case. But Department of Revenue thinks that this request is manifestly compatible with United States or Massachusetts policy. Now, I don't believe it is, okay? Because if I have it correct, if I read it correctly, which I included it in this, I believe it's a General Law Part 1, Title 17, Chapter 111, Section 1, there is a declaration of policy and purpose, okay? And when I read through it, it's like, did the Czechs apply this policy onto me? Well, if they're trying to apply this policy onto me now, okay. But did they apply it onto me when I was a 1-year-old? They didn't even provide a lawyer that would represent me when I was 1-year-old. They made it look like everything went fine.
In terms of thinking about the policy behind the decision of the Czech court and the decision of the Massachusetts court, to what extent should we be thinking about what's in the best interest of the child?
I think the best interest of the child right now, so that I have a relationship with him, and he has a healthy mother and father, environment, life, towards the whole life. Czech Republic, knowing what I know right now, I issued them an invoices. Now, I stand behind those invoices because they are up to the point of what they did. Now, I believe the right thing to do right now is do a new DNA test, pay those invoices, and apologize to me. Once this is done, I will be more than happy to accept the whole decision and have a relationship with the child, with the mother, and everything. If this is not going to happen, the whole relationship will forever be strained. Forever. It's almost like, okay, fine. How am I supposed to have a relationship if this is a cooking issue all the time, right? I don't see the problem why we can have a one simple, transparent DNA test, right? They will uncover, maybe I'm wrong, okay? But I don't believe that that's the case because my mom knows who the father is. And what they're trying to do in terms of like smear her is the same thing what they are trying to do to me right now. The whole case, you know, and whatever they filed, I'm sorry, to me it's one insult, okay? They manipulate it to look it like, you know, I'm something, I don't even want to go to that. So that's the policy. Then there is another thing, and it is the content of the packet that they, or the order that they sent from Europe here. Now, I have this is a notebook of mother that she used to write down her notes and things like this. Now, when she left the United States, I just found it and I was briefly going through it. And over there are a few pages where she literally is writing to herself a note about that she needs to learn to speak the truth. And I have it translated because I had to have it translated to translate it, so I have that. Now, I submitted it to the lower court, however, they rejected it because it wasn't translated at that time. So I have that. So to me, dispute the content of that order and however they came up to it and what the mother is saying, she basically is manufacturing things that are not right about me. Okay? So that's the second thing. And I hope I didn't miss what I wanted to say. If I do, you guys can ask me any questions, but I'm running out of time. I have like 39 seconds, so.
He's 9 years old now?
Yes. Yes. He's 9 years old. And I wish we had a great relationship, but as long as mother is going to be manufacturing things about me that are not true, and she's going to be presenting me to the child in this is not going to work with me. You know, it's almost better for a child not to have a father than to have a distorted relationship with the father. So, thank you.
All right. Thank you very much.
Good morning, Your Honors. Assistant Attorney General Adam Hornstein, my pronouns are he, him, and I'm here today on behalf of the Department of Revenue to urge you to affirm the decision of the Probate and Family Court below, registering and recognizing the child support order from the Czech Republic. As I'm sure the court is well aware at this point, under the Uniform Interstate Family Support Act, whenever a convention country, here the Czech Republic, presents a support order to a Massachusetts court, and that through here, as relevant, the Massachusetts Department of Revenue, that support order must be recognized. Again, this is section 7-708A, unless the defendant can prove an affirmative defense thereto. And here, respectfully, Your Honors, the defendant has not carried his burden to satisfy any of these affirmative defenses. As best as can be discerned from his brief, he advances two arguments on appeal. The first is under subsection B1. This is the idea that the Czech Republic's order is incompatible with public policy and some minimum standards of due process. Respectfully, the Department of Revenue submits that this order is compatible with Massachusetts public policy, including because the appellant here had counsel, had notice, had an opportunity to be heard, and that there is just nothing in the record that would otherwise substantiate his affirmative defense.
Well, so I look at this record, and at every stage, Judge Riley says, you know, check into something, provide evidence, and if I don't get any evidence, we're going to have a trial. We're going to have a trial on the merits. And then in October, we get a new judge, and suddenly trial on the merits is off the table, and only thing they're going to have is an evidentiary hearing on the sole issue, the amount of arrears. And so I don't know how we got from a situation where we're going to have a trial to see whether the father could prove one of these things to it suddenly he's out of it. I mean, it seems like there was a summary judgment that I don't see that happened in between. How do we get there?
Unfortunately, Your Honor, I was not a record counsel below, so I cannot speak to how we got from point A to point B. What I can say is, and this is, I think, evident in the record as well, is that the first judge ordered the Department of Revenue to procure and to provide the appellant with a number of documents translated from the Czech Republic that would help substantiate some of the allegations that he is making here today. But none of those defenses, as far as I can glean from the record, were ever developed. None of them were ever supported by any of the evidence, including those documents that were...
But how do we know that when suddenly the trial is canceled and Judge Tierney has found that he loses without ever having an opportunity for him to present his evidence?
Well, I imagine it's, again, difficult for me to speculate for what is or excuse me, what is not in the record. But as far as I can discern, it is not clear that the appellant could even carry a burden of persuasion, let alone proof here, again, to borrow from summary judgment language.
But usually there's like a summary judgment motion and there's affidavits and we see I know there are no depositions here, but
no.
I mean, I don't know how we find out that he can't present that, or he's never even, I mean, I didn't see, maybe I'm missing some submission where it was his opportunity to show what he would prove at a trial, but I didn't see that.
The docket is the docket, Your Honor, and again, I can't speak to the absence of what is or is not in the docket, and I regret that. I don't have that prescience to, again, explain how we got from point A to point B. But the fact remains is that based on what is in the record here today, again, there is nothing that he has submitted to this court or to the probate court that would substantiate an affirmative defense under Section 708B1, again, noting, as he acknowledges, that he had notice and an opportunity to be heard, or with respect to 708B4, this is the idea that there was some fraud in the procedure in the Czech Republic. Again, neither in his brief nor below has he submitted any proof that there was some fraud regarding the procedure. And I would note, too, and I think this is important, that under Chapter 209D,
Well, he says that, this is just in his brief, but he says that the delay in informing him of the check order was intentional on the part of judicial officials in retaliation of father making known the official's pattern and practice of corruption. If that were true, wouldn't that be a fraud in the procedure, depriving him of his right to appeal by depriving him of notice corruptly?
again, I don't know that it would, again, because as he acknowledges here, he did have notice of the proceedings, he did have counsel, he did have an opportunity to submit evidence.
Right, but he presents pretty strong evidence that he was not informed of the child support order until after the time to appeal. He's even got these emails where he tells his lawyer, as soon as you get it, appeal, as long as it's over $4,000, check money, not U.S. money. And the lawyer sends an email after the order's over saying, I haven't seen it, and then doesn't tell him about it. So, I mean, he kind of loses his right to appeal.
Well, let's keep in mind, again, I can't speculate on his evidence or his rendition thereof. The record, again, is the record. But under the statute, Your Honor, this court, of course, is not allowed to inquire as to any of the jurisdictional facts in the Czech Republic or to the underlying merits of the support order from the Czech Republic. The only thing that we can go on here is whether he can carry his burden of proof, his affirmative burden of proof to, under subsection B1, B4, or any of the other subsections. And that just never happened below.
But I know it didn't happen below, but as we discussed, we kind of just disappeared the opportunity to have it. I mean, do you agree that if he could show that he was fraudulently, by judicial action, not because his lawyer was incompetent, but judicial action deprived of his right to appeal, would that be a grounds for vacating? It's not obvious to me what the answer to that is, so I would...
And it's far from obvious as to what the answer to that would be to me as well. Obviously, there's a dearth of case law in this area. Is that a fraud in the procedure that resulted in the procurement of this child support order? We tend to think the answer is no if we're looking at the strict text of the statute. Is it procedurally different than it might have otherwise proceeded in an American court? Yeah, I think that's probably the case. But that is not the watchword here, of course. Again, we're not allowed to inquire into the jurisdictional facts. We're not allowed to inquire into the minutiae of Czech procedure. The idea here is whether it's compatible with some minimum notions of due process. And I think, again, where defendant has had notice, counsel, and an opportunity to be heard, that satisfies the due process minimums of the statute, particularly, Your Honor, where the whole reason this statutory scheme exists is through an international convention, and pursuant to that, the United States Congress directed all states have to adopt a version of this statute. Massachusetts, of course, did in adopting the Uniform Interstate Family Support Act because as a matter of international comity, we want these valid child support orders to be recognized in other countries, including the United States, and in the Commonwealth of Massachusetts.
Let me give you another head scratcher,
Sure.
Which is Judge Riley seems convinced that a pending appeal would mean that this order wouldn't be enforced. And I can't tell why he thinks that. Do you think he's right about that?
If a pending appeal in the Czech Republic, just want to make sure.
Yeah, that's what he seems to think, because he's asked Department of Revenue to go find out whether the appeal is pending.
Yeah.
And I couldn't understand why that would mean it wouldn't be, it certainly wouldn't be, it wouldn't work in the U.S. You couldn't say it can't be enforced until it's appealed.
Right. The Department of Revenue's position is that did not matter. Again, as I interpret it from my understanding of the record as it exists on appeal, the court asked the Department of Revenue to inquire into these matters, essentially to get discovery and to provide it to the defendant here so that he could potentially develop a record. And of course, the Department of Revenue did that. But where the Czech government, again, a nominal plaintiff here, is asking Massachusetts to domesticate and register this foreign support order, I cannot fathom that the mere existence of an appeal would stand as a barrier to the registration of it or the enforcement of it here in Massachusetts. Again, not a lot of case law in this, but I think that is the Department of Revenue's position. Obviously, the judge was concerned about it, ordered us to provide documents. Those documents were furnished, but that should not stand as an obstacle to registration here, Your Honor. Unless the court had any other questions, I would be pleased to yield the remainder of my time and to ask the court to affirm the decision below.
All right, thank you both. It's a pretty interesting case, which, as you say, not a lot of case law on it that we'll have to think about. Well, that concludes our sitting for today. I'd like to thank all the attorneys we had. I'd like to thank our clerk and our timekeeper, and definitely our court officer for keeping everything running, even on a day where things weren't going right. We really appreciate that. And with that, court will be adjourned until tomorrow, 9:30 a.m. in the Hale courtroom.